For convenience, I'll place these submissions on the screen. You'll also find them at tab 3.1 of your folders. Now, as can be seen in Chile's submission D, Chile requests the court to adjudge and declare that Bolivia has an obligation to take all appropriate measures to prevent and control pollution and other forms of harm to Chile resulting from its activities in the vicinity of the Salala River. And if we turn to submission E, slightly longer, Bolivia has an obligation to cooperate and to provide Chile with timely notification of planned measures which may have an adverse effect on shared water resources, to exchange data and information, and to conduct, where appropriate, an environmental impact assessment in order to enable Chile to evaluate the possible effect of such planned measures. Obligations that Bolivia has breached so far as concerns its obligation to notify and consult Chile with respect to activities that may affect the waters of the Salala River or the utilization thereof by Chile. In this presentation, I will show that based on the applicable principles of customary international law discussed by Professor Pelé yesterday, and on the facts that I shall discuss, neither of these submissions has any merit. With respect to the claim in submission D that Bolivia must take all appropriate measures to prevent and control pollution and other forms of harm to Chile, the claim is without object. And that no doubt explains why Chile said absolutely nothing at all about it on Friday, other than the distinguished agent's passing statement that Bolivia acknowledges the duty to consult and prevent significant harm. Otherwise, not a word on submission D. Madam President, the duty to prevent and control pollution is nothing new. As explained by Bolivia's agent yesterday, Bolivia takes environmental matters very seriously and always has respected the need to prevent and control pollution or other forms of significant transboundary harm. For its part, Chile has never asserted, much less demonstrated, that the very modest activities that Bolivia undertook in its territory in the vicinity of the Salala have caused the slightest pollution to the waters of the Salala or any other form of harm to Chile. Indeed, Chile expressly acknowledges in its written pleadings that it does not ask the court to specify precisely what measures Bolivia should take to prevent or control pollution, and nor does Chile explain in what way Bolivia failed to take such measures or breached any obligation in this respect. No doubt, this is because there is no evidence whatsoever that Bolivia has not taken appropriate steps when called for to prevent and control pollution. The plain fact is that the quality of the waters of the Salala that flow into Chile remains the same as it has been for almost 100 years since the drainage works were installed in 1928, unaffected by any form of human-generated pollution, and Chile has not shown the contrary. There being no dispute between the parties over this matter, as Professor Fauteux noted in his presentation, Chile's submission D is without object and should be rejected. As for Chile's submission E, that Bolivia breached its obligation to notify and consult with Chile regarding activities that may adversely affect the Salala, this too has no merit. As Professor Pelé showed yesterday, a duty to notify and consult under customary international law only arises when a risk of significant transboundary harm has been confirmed. Yet none of the very modest activities that Chile hinges its claim on gave rise to any risk of harm, let alone significant harm. On Friday, Counselor for Chile first referred to a concession granted by Bolivia in 2000 to the RTUK company to commercialize the waters of the Salala. Now, it's true that Chile protested this concession. However, what Council failed to mention is that RTUK took no steps to implement its concession with concrete plans involving the use of the waters of the Salala, and the concession was thereafter cancelled by Bolivia in May 2003. Next, Council mentioned tentative proposals by the Department of Potosí to construct a weir, or small dam, along the Salala and a mineral water bottling plant. However, neither of these ideas ever got off the ground either, and accordingly there was nothing to notify or consult over. As for Bolivia's establishment of a temporary fish farm, which Ms. Klein-Kranenberg described as unsuccessful and abandoned, and a minor military post and 10 small houses referred to by Professor Bosson de Chazon, these too did not give rise to a risk of any harm, much less significant harm, to Chile. And that explains why Chile never alleged that it suffered any such harm, and it never objected to these initiatives, at least not until it instituted this case. In reality, the matter was a non-issue between the parties, and there was no breach by Bolivia of any obligation to notify or consult. With that overview, Madam President, the remainder of my presentation will be in two parts. First, I shall address the background to Chile's claims to show how the facts lend no support for its two claims, submissions D and E. And secondly, drawing on Professor Pellé's presentation on the applicable law, I will turn to the legal shortcomings of Chile's submissions, which further undermine its claims. Now, the background facts relevant to Chile's claims are straightforward and largely uncontested. I have already noted that the RTUK concession mentioned by Council on Friday never even reached the pre-implementation stage, and RTUK never used the waters before the concession was cancelled in 2003. The other matters at issue were first raised in a diplomatic note that Chile sent to Bolivia on the 7th May 2012. In that note, which you will find under tab 3.2 of your folders, Chile drew attention to an announcement apparently disseminated in the press, but not annexed by Chile, made by the government of the Department of Potosí in Bolivia concerning the possible construction of a fish farm along the Salala waters and other potential projects involving a weir and the establishment of a mineral water bottling plant. Significantly, Chile did not question Bolivia's entitlement in principle to carry out these projects. To recall what Chile's said in its memorial, and I quote, "The Chilean government observes attentively the various initiatives with this water resource in Bolivia, and that could be consistent with Bolivia's legitimate rights to use this resource upstream from the boundary in accordance with international law." This note did not request any particular information from Bolivia. Rather, it simply indicated that Chile would be interested in receiving timely information about the projects prior to their concretization. Now, Bolivia responded by a note dated 24 May 2012, and in that response, Bolivia repeated an invitation it had made in 2011 for Chile to make a joint visit to the region, and Bolivia underscored that in accordance with its culture of dialogue, Bolivia remained willing to explore ways to lead to a common understanding for movement in the treatment of the matter. Chile repeated its request for information at the appropriate time in another note sent on the 9th of October 2012. Bolivia's response came on the 25th of October 2012, just 2 weeks later. In its note, Bolivia once again repeated its invitation to Chile to conduct a joint visit to the area under the auspices of the Chile-Bolivia political consultation mechanism. However, Chile never followed up on that proposal. In any event, the fish farm was a one-time event that caused no pollution or other harm to Chile, and Chile has never claimed as much. To the contrary, in their first report filed with Chile's memorial, Chile's experts state, and I quote, "Using an internationally accepted morphological quality index, MQI, the river is classified in good status. A healthy population of rainbow trout with a wide range of sizes and weights demonstrates that the general state of the river, with respect to perennial flows, water quantity and quality, and the availability of food is sufficient to maintain a healthy fish population." Regarding the possible construction of a weir and a mineral water bottling plant, as I said, Chile simply refers to a 2012 announcement by the government of the Department of Potosí about a possible project, but provides no evidence concerning any actual implementation of these proposals. And as Bolivia explained in its counter memorial, neither of these projects got off the drawing board, and they never reached the implementation or even the pre-implementation stage. And accordingly, any obligation to notify was not triggered since there was nothing to notify. Throughout 2013 and into 2014, the parties exchanged a number of notes in which they basically repeated their positions, with Bolivia continuing to push for discussions and field observations under the political consultation mechanism. By 2014, the fish farm was a forgotten matter, and it was apparent that neither the weir nor the bottling plant were going forward. In short, the matter was not pursued. Indeed, what Chile's council neglected to tell you last Friday is that since its last note on the subject dated 27 March 2014, Chile has made no further reference over the past 8 years to these events in diplomatic correspondence, and no allegation of breach of an international obligation by Bolivia until such a claim was surprisingly advanced in these proceedings. Now, turning to the question of the military post and the 10 small houses, the court will see from the image on the screen, taken from the drone video that Bolivia supplied in Annex 30 to its rejoinder, and that Professor Eckstein displayed yesterday, that these rather modest installations are located about 3 kilometers upstream from the international boundary in Bolivian territory, with the houses situated well back from the Orientales, or southern branch of the Salala. On the 7th of February 2017, Chile sent a note to Bolivia in which it requested information concerning the use of the waters of the Salala with respect to these installations. And Bolivia duly responded on the 24th of March 2017, stating that it would let Chile know regarding the requested information as soon as it was available. You can find these notes under tab 3.3 of your folders. Now, Bolivia followed up with a further note to Chile dated 25 May 2017, which is in tab 3.4. In this note, Bolivia informed Chile that the extremely modest infrastructure that existed posed no danger of generating any pollution or affecting the water quality of the Salala Springs, given that the houses were uninhabited, as they remain today. And with respect to the military post, Bolivia first noted that the preservation and conservation of the waters of the Salala were a permanent concern of Bolivia. Those were the words Bolivia used at the time. And then Bolivia explained, and I quote, that appropriate mechanisms that ensure the preservation and conservation of the aforementioned waters have been provided, and that therefore the use of the waters is minimal and the disposal thereof is controlled through a system of basic sanitation that prevents contamination in the area. Now, Chile made no response to that note, another point passed over by Professor Boisson de Chazorn on Friday. And Chile did not raise the matter or complain of any pollution thereafter. And as I have said, what is clear is that there has been absolutely no pollution or other form of harm emanating from the Bolivian side of the boundary at any time, and no complaint from Chile to the contrary. And all this shows that Bolivia did exercise due diligence in taking measures to prevent pollution and did cooperate by responding to Chile's query. And given that none of Bolivia's very limited activities have ever given rise to a risk of transboundary harm, let alone significant transboundary harm, it follows that there are no factual grounds for either of Chile's submissions, D or E. I now turn to the legal factors, which, when considered together with the facts, further undermine Chile's claims. Now, because these have already been discussed in part by Professor Pele, I can be relatively brief. I'll first deal with Chile's submission D, pursuant to which Chile asked the court to adjudge and declare, as I've noted, that Bolivia has an obligation to take all appropriate measures to prevent and control pollution and other forms of harm. And secondly, after that, I will turn to submission E, the allegation that Bolivia has breached its obligation to notify and consult Chile with respect to activities that, to use Chile's words, may affect the waters of the Salala or the utilization thereof by Chile. So starting with submission D. The facts show that there is no dispute between the parties over the need to take appropriate measures to prevent and control pollution. Although it should be recalled that, contrary to Chile's submission D, the applicable standard is to prevent significant harm, not just any harm. Now, I mention this, Madam President, distinguished judges, because, as Professor Pele noted, Chile, in its memorial, advanced the rather extreme and untenable proposition that Bolivia is under an obligation to take measures to eliminate as far as possible the risk of pollution or causing any other kind of harm in Chile. While in its later pleadings, Chile acknowledged that the relevant standard concerns significant harm, not just any harm, this is not reflected in Chile's submissions as they stand today. Now, notwithstanding that precision, there are three key points which I would respectfully ask the Court to bear in mind in assessing Chile's submission D. First, Chile has at no time alleged that Bolivia failed to control pollution or other forms of harm. Second, Bolivia itself acknowledged in its note of 25 May 2017 that pollution and preservation and conservation of the Salala waters was one of its permanent concerns. And third, there has been no pollution or harm, much less significant harm, with respect to the waters flowing into Chile. There being no dispute between the parties on these points, Chile's submission D is without object and should be rejected. As the Court has previously noted, it has jurisdiction over legal disputes, with the consequence, and I quote from the Court's judgment in the preliminary objections in the Marshall Islands versus United Kingdom case, the existence of a dispute between the parties is thus a condition of the Court's jurisdiction. And as we all know, the Court has frequently recalled that in order for a dispute to exist, it must be shown that the claim of one party is positively opposed by the other. Or in other words, once again to quote the Court, the two sides must hold clearly opposite views concerning the question of performance or non-performance of certain international obligations. In the present case, while the parties may have different views over some issues relating to the status of the waters of the Salalah, the facts that I have discussed show that they do not hold different views over the obligation to control pollution or other forms of significant transboundary harm, as to which I would recall there has been none. Thus, there is no legal dispute on this issue that the Court needs to decide, and that being the case, Chile's claim set out in Submission D is, as I said, otiose, and the Court, in our respectful submission, should decline to exercise jurisdiction over it. Yet even if that were not the case, the obligation to take all appropriate measures to prevent causing significant transboundary harm is not a one-way street, as Chile's submissions imply. As the Court recognized in the pulp mills case, all riparian states, regardless of whether they are downstream or upstream states, have equal obligations in relation to the obligation to act with due diligence with respect to all the activities that take place under the jurisdiction and control of each of the parties. And I would simply point out that this mutual obligation is reflected in Bolivia's submission F, but it finds no place whatsoever in Chile's submissions. Madam President, now let me turn to Chile's assertion that Bolivia has breached the obligation to notify and consult with respect to the very limited activities undertaken by Bolivia in the vicinity of the Salalah. This, as you will recall, is the subject of Chile's submission E. As Professor Pelé has explained, in its judgment in the construction of a road and certain activities cases, the Court clearly articulated the nature and the scope of the obligation to notify and consult with respect to activities along a river giving rise to a potential risk of significant transboundary harm under customary international law, which is the applicable law in this case. First, the state undertaking such activities must assess whether there is a risk of significant harm. Second, only if such assessment indicates that there is such a risk is a state obliged to conduct an environmental impact assessment. And third, again, only if the impact assessment confirms that there is a risk of significant transboundary harm is the obligation to notify and consult triggered. But these rules not only reflect customary international law, they're based on good sense and reasonableness. Clearly, very minor activities that give rise to no risk of significant transboundary harm do not require an environmental impact assessment to be prepared or notification or consultation with other states. Were it otherwise, both upstream and downstream states, whether along a large river such as the Rhine or the Danube or the Mekong or smaller rivers such as the Salalah, would be inundated with wholly unnecessary environmental impact assessments, the need for consultation, and bureaucratic costs, when in reality the activities in question are insignificant. That's what we have here. Bolivia's activities were insignificant. There was absolutely no risk of significant harm or any harm. I've already noted that the RTUK concession, which Council seems to rely on the other side, resulted in no concrete plans to use the waters of the Salala, and the abandoned or unsuccessful fish farm posed absolutely no risk of any harm, and that Chile never complained otherwise. I also have explained that Bolivia never put into action or operation its preliminary ideas for building a weir or a water bottling plant using the waters of the Salala, and in such circumstances there was clearly no risk of any significant harm to Chile. And that being the case, there was no breach by Bolivia of any obligation owing to Chile, whether a duty to notify and consult or otherwise. To recall what the court said in its judgment in the Gabchikov and Azimaras case, and I quote, "A wrongful act or offence is frequently preceded by preparatory actions which are not to be confused with the act or offence itself. It is well to distinguish between the actual commission of a wrongful act, whether instantaneous or continuous, and conduct prior to that act, which is of a preparatory character and which does not qualify as a wrongful act." Here, we neither have a wrongful act nor, for most of these examples, any preparatory action whatsoever. If I turn to the 10 small houses that you saw on the video and the military post, Bolivia assured Chile, as a matter of good faith and neighborliness, that these activities presented no risk or danger to Chile because appropriate measures had been taken to prevent any such risk. And I would suggest that the correctness of Bolivia's assurance is borne out by the fact that there is absolutely no evidence that these activities produced the slightest pollution or other forms of harm, let alone significant harm, and that it's telling that Chile itself never thereafter complained of any such harm. In short, at no time, including since the emergence of the dispute in the late 1990s, has Bolivia undertaken any activities that could potentially have a significant adverse effect on Chile with respect to the waters of the Salala. And that not only underscores Bolivia's good faith, it equally, I would suggest, exposes the artificiality of Chile's claims in submissions D&E. Now, Madam President, in concluding my presentation, I think it's useful to place Chile's claims as reflected in submissions D and E in perspective. The facts show that Chile has had unimpeded use of all of the waters of the Salala that flow across the border for over 100 years. Under the FCAB concession, those waters were supposed to be used for steam locomotives, but Chile itself acknowledges that the waters were used for human consumption, copper mining by the state-owned Codelco mining company, and other mining activities such as the saltpeter industry. In other words, Chile has up to today, it's been free up to today to use all of the waters of the Salala as it chooses, and Bolivia has never impeded or caused the slightest harm to those activities. Now, given that state of affairs, coupled with the fact that there is absolutely no factual or legal basis for Chile's claims that Bolivia breached any obligations owing to Chile with respect to the Salala, there is, we have to say, a certain cynicism in Chile's claims. How can Chile, which has had complete use of all of the waters of the Salala for decades, waters the quantity and quality of which Bolivia has in no way compromised, how can Chile accuse Bolivia of breaches. The claims ring hollow. And it's for these reasons, Madam President, members of the Court, that Bolivia respectfully requests that Chile's submissions D and E be rejected. Madam President, that concludes my presentation. I thank the Court for its attention. We will now be turning to Bolivia's counterclaims, and I would ask that the floor be given to Professor Foto to commence this part of Bolivia's case. Thank you.
I thank Mr. Bundy for his statement, and I now give the floor to the next speaker, Professor Matias Foto. You have the floor, Professor.
Yes, thanks very much, Madam President. Madam President, distinguished members of the Court, it falls to me this afternoon to introduce Bolivia's counterclaims, and then I will pass on to the examination of the first of them. Mr. Bundy will follow me to the podium to look at the second and third of these counterclaims. Madam President, as we underscored yesterday, the position presented by Chile before the Court is disputable in a number of respects. Firstly, Chile sees the water of the Silala as but a natural watercourse, and yet it's fully evident that it has been subject to major works, drainage mechanisms, and channelization. And Chile holds a conception, a very unilateralist conception, of those rights relative to the waters of the Silala, saying nothing in its final submissions about Bolivia's rights. This explains that Bolivia felt the need to formulate in its counter memorial, in this case, not only a number of claims in response to Chile's main claims, but also 3 counterclaims. These claims were formulated as follows in the counter memorial. You can find them under tab 4.1 of the judge's folders, and they're both in French and in English, with a few minor changes to the French translation from the registry. So, they are formulated, as I say, thus in the counter memorial. A. Bolivia has sovereignty over the artificial channels and drainage mechanisms in the Silala that are located in its territory, and has the right to decide whether and how to maintain them. B. Bolivia has sovereignty over the artificial flow of Silala waters, engineered, enhanced, or produced in its territory. And Chile has no right to that artificial flow. C. Any delivery from Bolivia to Chile of artificially flowing waters of the Silala and the conditions and modalities thereof, including the compensation to be paid for said delivery, are subject to the conclusion of an agreement with Bolivia. Now, in its rejoinder, Bolivia clarified that the third counterclaim was forward, not backward-looking, and that if the channels and other installations were to be dismantled, then, of course, the second and third counterclaims would become moot. These 3 counterclaims were formulated in compliance with Article 80 of the Court's rules. They clearly fall within the Court's jurisdiction and are equally clearly directly connected with the subject matter of Chile's claims. Chile has moreover indicated that, I quote, would not contest admissibility of these counterclaims, and the Court took note of this in its order of 15 November 2018. Subsequent to the filing of Bolivia's counter-memorial, Chile indicated to start with that a second round of written pleadings wasn't necessary and that it would be appropriate to move immediately to the oral phase of the proceedings, and that included on the counterclaims. After the court deemed necessary the filing of a reply and a rejoinder on the question of counterclaims alone, and after these were filed, Chile nonetheless requested the court to be allowed, I quote, the right to submit an additional pleading on the counterclaims. And the court authorized that. On that occasion, Chile submitted new experts' reports on which Bolivia has not had the opportunity to comment in writing. Now, the written exchanges on counterclaims have allowed the points of view of the parties to converge on some issues and to bring useful clarifications regarding their respective legal positions. Certain points still remain at issue, and they will be the subject of our presentations this afternoon. The first counterclaim is unambiguous. Bolivia is requesting the court to adjudge and declare that it has sovereignty over the channels and other infrastructure located on its territory, and that it has the right to decide whether and how these installations should be maintained. This claim shouldn't pose the slightest problem, and this for two reasons. Firstly, because such sovereignty is clearly recognized under international law, including in the court's jurisprudence. And secondly, because in its written pleadings, Chile concedes the principle that Bolivia does indeed possess such sovereign rights. After noting that these installations are located exclusively on Bolivian territory, Chile indicates, indeed, that it accepts that, I quote, Bolivia's ownership over the infrastructure in its territory. Ownership which, as Chile spells out, derives from the fundamental principle of territorial sovereignty. Equally explicitly, Chile states, I quote again, that it fully recognizes Bolivia's sovereignty over the artificial channels and drainage mechanisms in the Salala that are located in its territory, and the right to decide whether and how to maintain them. Chile also endorses Bolivia's assertion that the restoration of the wetlands might justify this infrastructure to be dismantled in the future, and even encourages Bolivia to restore these areas. Finally, Chile recognizes, and I'm quoting again, that it has no right to require Bolivia to install or maintain infrastructure for its benefit. Chile adds in its reply that the first counterclaim would not be contested by Chile, from which Chile infers that there is no dispute about that counterclaim, and thus that it is moot. In its last written pleadings, Chile is of the view that the first counterclaim is uncontroversial, and that the court has no jurisdiction over it. Why? Because there is no dispute. The final submissions of Chile, however, are rather more confused on this point, because they indicate that the first claim either falls outside the court's jurisdictional scope, or alternatively that it is moot, or again that it should be dismissed. The positions expressed by Chile, which I've just set out, call for two comments. First of all, Chile is of the opinion that when a claim has become moot because there is no longer disagreement between the parties, the court cannot rule on it. But to come to the conclusion that the first counterclaim is moot we must necessarily first find that the parties agree on the point in issue. In other words, for the court to come to a finding that the claim is moot, that there's no dispute, there needs to be a declaration, first, that Bolivia does indeed possess the sovereign rights it claims. Then, the fact that Chile doesn't contest the first counterclaim and considers that it is uncontroversial and asserts that there is no dispute necessarily implies that Chile acquiesces to the entirety of this claim unconditionally. Indeed, Chile's final submissions on the first counterclaim are not accompanied by a reservation of any sort. Chile even clarifies in its last piece of written proceedings that the positions of these parties regarding this counterclaim dispose of the dispute in its entirety. I quote them there. And Chile also points out that in its view this claim is even a truism. Now, Madam President, I could stop there. The declarations of Chile and its final submissions suffice, apparently, to vacate the question insofar as they formally and expressly accept without the least reservation the first of Bolivia's counterclaims. Chile reiterated Friday, moreover, and I quote then, that it has no objection to Bolivia dismantling the channels. But the problem is that Chile blows both hot and cold regarding this first counterclaim. On Friday, Chile presented to you an idealized version of its position, but staying silent on the limit that it imposed on the first counterclaim in its written pleadings. Limits which Professor recalled yesterday that Chile didn't think worth going into on Friday. These pleadings imply, reversing the formulation of its final submissions, that Bolivia's sovereign rights would be subject to a certain number of conditions, as revealed by the repetition in Chile's written pleadings of terms such as insofar as, without prejudice to, provided, or unless. In its rejoinder, Bolivia underscored the ambiguities inherent in Chile's position, but these have not been entirely dissipated since then, and these ambiguities are varied. To start with, in the written pleadings, Chile makes the right of Bolivia to dismantle channels and infrastructures conditional on its own right to an equitable and reasonable utilization of the waters of Silala, that is, its current utilization of these waters. By invoking the right to equitable and reasonable utilization and linking it to the first counterclaim, Chile seems to consider that the effect of dismantling infrastructure on the flow of the Silala should be considered as a potential violation of its right to use the waters of the Silala. Now, this is tantamount to pleading that Chile's current usage, or any possible future use of these waters, could be opposed to Bolivia's right to dismantle the artificial installations. This assertion empties of substance Chile's apparently unconditional acceptance of the first counterclaim. Chile claims, moreover, that the dismantling of the installation should not, I quote them, impair the natural conditions of the Silala water system. But what is both ambiguous and contradictory in these terms? The aim of dismantling the infrastructure, were it to happen, wouldn't be to impair the natural state of the Silala, but quite the contrary, to restore this natural state. Of course, subject to the prohibition of causing significant transboundary harm. But this prohibition is very different from the purported obligation Chile relies on not to impair the natural conditions of the Silala. What Chile is really suggesting via this purported obligation is that it has some sort of acquired right to the Silala being maintained as it is now, and thus to Chile's current use of those waters, a right which would trump Bolivia's right to dismantlement. This is tantamount, once again, to purely and simply deny the first counterclaim. Chile seems also to be of the opinion that dismantling of these installations could, in itself, be characterized as harm. Harm which, as such, would limit the sovereign right of Bolivia to dismantling. According to Chile, Bolivia would, in case of dismantling, be held to an obligation to notify all measures, I quote, which may have an adverse effect on shared water resources. End of quote. Now that goes far beyond what customary international law imposes, as Alain Poulet recalled yesterday. Once again, this in reality amounts to Chile claiming a right to scrutiny and monitoring, and even the power of veto over the sovereign right of Bolivia to dismantle artificial installations. And this contradicts the first counterclaim, and it's wholly unjustified under international law. As I pointed out, Chile didn't totally clarify its position on these different points in its last written pleadings, nor in its first round of oral hearings, whereas already in its rejoinder, Bolivia called on Chile to make the necessary clarifications. In paragraph 119 of its additional written pleading, Chile states that the reference in its final submissions to its right to current usage of the waters of Silala is without effect for the future and was solely intended to have its current usage of the waters of the Silala recognized as compliant with international law. Well, that is a superfluous claim, to say the least, since, as was said yesterday, Bolivia has never taken any measure against such usage, and that usage has never been hampered in any way. Chile adds in the next paragraph, a paragraph that was repeated expressis verbis by the agent of Chile on Friday, I'm quoting, thus, a reduction of, if any, of the cross-boundary surface flow resulting from the dismantling of the channels in Bolivia would not be considered a violation of customary international law, end of quote. But the same paragraph, you read immediately afterwards, unless the obligations that Bolivia has accepted were somehow engaged. By referring inter alia here to the principle of equitable and reasonable utilization. Madam President, it's difficult to understand the thrust of Chile's argument. It amounts to opposing the rights to dismantling to the right of using the water of the river, as if these two rights could be incompatible one with the other. Once again, this implies that Chile would have some sort of right to its current utilization of the water, which could be affected by the dismantling of the installations. Yet again, this implicitly amounts to claiming an acquired right to this current usage. Chile's claim is all the more confusing because elsewhere Chile claims, and I'm quoting them again, the full restoration of the wetlands would have minimal impact on the cross-border flow into Chile. But putting yourself in Chile's shoes, you don't know why, you don't see why it would be necessary in this case to subject the dismantling of installations to compliance with Chile's rights to the right to reasonable and equitable utilization of the water, since, according to Chile, the dismantling would in any event have no effect on this usage. Unless, that is, that although Chile denies it, it is in reality perhaps a little more anxious than it lets on regarding the substantial flow reduction which would ensue from a dismantling of the artificial installments. Equally confusing is the assertion whereby the first counterclaim could be undermined by, I quote, Bolivia's decision not to remove the channels and restore the wetlands in its territory as it could have done after the termination of the 1908 Bolivian concession in 1997. This argument was suggested on Friday, again, in more subliminal fashion by Madame Klein-Kannenberg. But if Bolivia indeed has the right to dismantle the artificial installations, how could not exercising this right in the past affect said right? Unless it was thought that this was a right enjoying a precarious existence which could lapse by obsolescence, which would surely be surprising, to say the least, given that it is a sovereign right. In its written proceedings after the memorial, Chile became rational once more, restricting the scope of the no-harm principle to significant transboundary harm. But there again, a degree of uncertainty remains. Now, I'm not going to return here to the question of the balancing of interests which Professor Pele delved into yesterday. However, I do have to underscore that it is surprising that in one section of its last written pleadings devoted to the right to dismantle the artificial installation, Chile refers yet again, this time seen through the prism of the obligation not to cause significant transboundary harm, to the right of equitable and reasonable utilization of the waters of Silala. Now, this is mixing up two things which are extremely different. If one can be sure that any dismantling of the installations will be done in compliance with the obligation to not cause significant transboundary damage, then by contrast, dismantling cannot be considered as being an infringement of Chile's right to the equitable and reasonable utilization of the waters of the Silala. If, as the experts for Bolivia estimate, this dismantling will lead to a substantial reduction of the flow of the surface water of the Silala, this reduction will not affect the right of Chile to the equitable and reasonable utilization of the waters of the Silala, and cannot be characterized as such as a significant transboundary harm, unlike what Chile suggests. By replacing yet again this debate within the bounds of equitable and reasonable utilization, Chile seems once again to seek to void the first counterclaim of its substance. Furthermore, and finally, paragraph 118 of its last written pleadings, Chile reiterates its position whereby the right to dismantling would be subject to the obligation to notify, inform and consult Chile with respect to any planned measure. This very extensive allegation does not correspond to applicable customary international law, as Professor Pele recalled yesterday. So that cannot limit the sovereign right of Bolivia to dismantling. On all these points, Madam President, we expect Chile to clarify its position and harmonise its explanations and its allegations with its final submissions. Distinguished members of the Court, thank you for your kind attention. Mr. Bundy will now pass to the examination of the second and third counterclaims. I would be grateful, Madam President, if you will call Mr. Bundy to the podium. Thank you.
I thank Professor Forto for his statement, and I call Mr. Bundy back to the podium, please.
Thank you, Madam President, distinguished judges. In this final presentation of Bolivia's first round, it falls to me to address Bolivia's second and third counterclaims. Now, these two counterclaims are set out as counterclaims B and C in the submissions to Bolivia's rejoinder. For ease of reference, you'll find them under tab .51 of the folders, and I will display them on the screen. In counterclaim B, perhaps I will display them on the screen. Counterclaim B, as you can see, reads as follows. Bolivia has sovereignty over the artificial flow of the Salala waters engineered, enhanced, or produced in its territory, and Chile has no right to that artificial flow. And counterclaim C is cast in the following terms. Any delivery from Bolivia to Chile of artificially flowing waters of the Salala and the conditions and modalities thereof, including the compensation to be paid for such delivery, are subject to the conclusion of an agreement with Bolivia. Now, in order to explain the content and justification for these two counterclaims, my presentation will proceed in four parts. First, I will explain the general principles on which the counterclaims are based. Secondly, I will review the relevant background that provides important context for the counterclaims. Third, I will take up Bolivia's second counterclaim, that's counterclaim B, in order to explain what is meant by and what the justification is for Bolivia's claim that it has sovereignty over the artificial or enhanced flow of the Salala in its territory, and that Chile has no corresponding right to that flow. And fourth and finally, I will address the third counterclaim in order to explain why Bolivia maintains that in the event Bolivia decides to exercise its right to dismantle the canal works, as Professor Forto has just discussed, and yet Chile indicates, as it has done in the past, that it wants to continue to receive its share of waters of the Salala based on the enhanced surface flow that the channelization produces. The cost of maintaining the channels and the delivery by Bolivia to Chile of such enhanced flow would need to be subject to the conclusion of an agreement between the parties. Now, with that brief introduction, Madam President, let me start with the general principles on which counterclaims B and C are based. I'd like to mention three such principles. The first, discussed by Professor Forto, is that Bolivia has sovereignty over the man-made canal works constructed in its territory by a private company in 1928, and that Bolivia thus has the right under international law to dismantle those works, for example, to restore the Salala and its environment to their natural state if Bolivia so chooses. I won't repeat what Professor Forto has just said on this point, other than to emphasize that Chile does not dispute this right, although, as I shall show, this was not always its position in the past, and there is no guarantee that this will remain its position in the future. Second, the consequence of Bolivia's right to dismantle the channels is that Chile has no vested or acquired right to an equitable and reasonable share of any enhanced surface flow that the canal works may produce over and above the natural flow and natural surface flow and groundwater flow of the Salalah. And when I speak of the surface flow, I mean the quantity and quality of the waters that would flow across the border without the canals. Now, while the experts of the parties differ on the magnitude of the effect that the installed canals have had in increasing surface flows, they agree that dismantling the canals will have some such effect in diminishing the surface flow and increasing the groundwater flow instead. The important point is that whatever the size of that effect, in the event Bolivia dismantles the canal works as is its right, Chile cannot complain that by virtue of that act it has been deprived of an equitable and reasonable use of the waters of the Salalah. As Professor Pelé noted yesterday, Chile has acknowledged this as a matter of principle in its additional pleading. Just to recall Chile's own words, and I quote, "Thus a reduction, if any, of the cross-boundary surface flow resulting from the dismantling of the channels in Bolivia would not be considered as a violation of customary international law," and then Bolivia added this somewhat ambiguous caveat, "unless the obligations that Bolivia has accepted were somehow engaged." Now, this brings me to the third principle underlying Bolivia's counterclaims. As was also observed by Professor Pelé, Bolivia, too, is entitled to an equitable and reasonable utilization of the waters, just as Chile. This principle is reflected in Bolivia's Submission 1C in the counter-memorial, which states that Bolivia and Chile are each entitled to an equitable and reasonable utilization of the naturally flowing Salalah waters in accordance with customary international law. But in contrast, Chile's submission, the relevant submission, which is their Submission C, only asked the court to adjudge and declare, and I quote, "Under the standard of equitable and reasonable utilization, Chile is entitled to its current use of the waters of the Salalah River." There is nothing about Bolivia's corresponding right to an equitable and reasonable use of the waters, nor is there anything about Chile's professed recognition of Bolivia's right to dismantle the channels in its territory, which necessarily means that Chile has no entitlement to its current use of the surface flows of the waters in perpetuity. Now, in its application, Chile even went so far as to threaten to request provisional measures, and I quote from the application, "Should Bolivia engage in any conduct that may have an adverse effect on Chile's current utilization of the waters of the Salalah River." Now, that was a pretty extraordinary threat, given that Chile then, as now, is receiving all of the waters of the Salalah. And not only did Chile's threat to bring provisional measures amount to an implicit rejection of the principle that Bolivia, as the upstream riparian, also has an entitlement to an equitable and reasonable share, it also effectively denied Bolivia's right to dismantle the drainage system situated in its own territory, because that may have an adverse effect on Chile's current use of all of the waters. Now, on Friday, Ms. Klein-Krenenberg rhetorically asked, why has Bolivia not dismantled the channels since it terminated the FCAB concession in 1997? Now, in addition to Professor Forteau's remarks on this point, I would suggest that Council look no further than Chile's own application, which I said threatened provisional measures if Bolivia engaged in any conduct that may have an adverse effect on Chile's current use. For its part, Bolivia had no desire to exacerbate the dispute. In short, Chile's application instituting this case and its submissions give every impression that Chile views these proceedings as a one-way street. It has rights, Bolivia has obligations. Now, obviously, this is untenable. To the contrary, the fact that Chile has no acquired right to the enhanced flow caused by the construction of the canals, coupled with Bolivia's own entitlement to an equitable and reasonable share of the waters of the Salala, are important factors to take into account in considering Bolivia's second counterclaim. And as for the third counterclaim, these factors also underpin the need for there to be an agreement if in the future Chile wishes to maintain the status quo and the current surface flows rather than have Bolivia exercise its right to dismantle the canals. Madam President, having recalled those basic principles, I now turn to the second part of my presentation in which I will discuss certain aspects of the factual background that place Bolivia's counterclaims in and provide context for those counterclaims. Now, as you've heard, the original concession to use the waters was granted by Bolivia to the private FCAB company pursuant to a deed of concession entered into in 1908. The concessionaire announced the intention to build intake works in Bolivian territory for the purpose of using the waters for its steam locomotives, because the waters then being used by the company were said to cause corrosion in the locomotives and were thus unfit. The agent representing FCAB also declared that the concessionaire would respect the legal provisions containing any right that might impair the concession, and further declared to leave 1/3 of the collected waters for Bolivia for any service that may be necessary at some distant time in the future. Thus, even at that time, it was recognized, at least by the concessionaire, that Bolivia had an entitlement with respect to the waters of the Salala, even though it was not then using them. In 1928, ostensibly to inhibit the breeding of insect eggs in the Salala headlands and to avoid contamination of the potable water supply to the city of Antofagasta, why that was relevant, since FCAB was supposed to be using the waters for locomotives, not for the people of Antofagasta. But ostensibly to inhibit these insect eggs, FCAB constructed the series of channels in Bolivian territory that clearly affected the flow of the surface waters. Otherwise, there would have been no need for the channels. Now, significantly, Chile admits in its memorial that contrary to the terms of the FCAB condition, from the early 20th century onwards, the waterworks, pipelines, and infrastructure developed by FCAB allowed for the efficient use of the waters in Chile, and I quote from Chile's memorial, initially for human consumption and railway operation, later increasingly for other industrial purposes. Moreover, as Professor Eckstein observed yesterday, given the uses to which FCAB actually put the waters, it strains credibility to believe that the railway company built literally thousands of meters of canals and pipes in Bolivian territory merely to reduce insect eggs. To the extent the works would have increased the surface flow, it clearly would have been to the benefit of the railway company and later Chile. Now, as you've heard, on the 14th of May, 1997, Bolivia canceled the concession on the grounds that the waters were not being used for their original purpose, i.e. for the steam locomotives, which FCAB in the meantime had phased out of service. And Chile raised no objection to the cancellation of the concession. By 2000, the use of the waters of the Salalah had emerged as a serious issue between the parties. Accordingly, the parties established a joint technical commission which started taking some rudimentary measurements on each side of the boundary. And this was followed in 2004 with the creation of a joint working group on the Salalah issue and a joint technical commission to exchange views and carry out joint technical and scientific studies on the nature, origin, and flow of the waters of the Salalah. In 2006, the parties' working group on bilateral affairs placed the Salalah issue on its agenda and agreed that a further meeting should be held, and I quote, to unify criteria that would allow a final, practical, and satisfactory solution for both parties to be reached. To that end, on the 10th of June 2008, at the third meeting of the Bolivia-Chile Working Group on the Salalah issue, it was agreed that two aspects of the issue would be pursued simultaneously. One, a joint study on technical issues, and two, conclusion of an immediate basic agreement on the topics on which there is consensus. With respect to this initial basic agreement, the working group acknowledged that both countries had sufficient knowledge at that time to advance the joint determination of the criteria and formulas to solve the Salalah issue, with the aim that this initial agreement would then be perfected later by a final agreement incorporating the results of the joint technical studies to be carried out. This was followed in June 2008 by a meeting of the Bolivia-Chile Political Consultation Mechanism, at which the meeting the parties agreed that the content of an immediate basic agreement, and I quote, that takes into account the water resource in its existing uses, the rights of each country, and the means and mechanisms for its use in order to generate economic benefits for Bolivia, taking into account the sustainability of the resource, would be exchanged within the following 60 days. On the 14th of November 2008, the joint working group on the Salalah issue met again, and at that point the group proposed the conclusion of this provisional agreement, which would serve as the basis for the final agreement. It was agreed at that time that the waters freely available and in Bolivia and not used by Bolivia would be made available for use in Chile, and that a mechanism would therefore be agreed that allows for the constitution of these exploitation rights at the border, as well as the value for its exclusive use by Chile. The working group also agreed that Bolivia would not affect the nature and continuity of such waters. And the implication of this last point was that Bolivia would not dismantle the canal works, since that would inevitably affect the nature and continuity of the surface waters, in other words, the quantity and/or quality of the flow. By 29 July 2009, the parties had agreed on the text of a basic initial agreement, which, along with the results of the scientific studies the parties agreed to undertake, would form the basis for the final long-term agreement. Now, you'll find the text of that initial agreement under tab 5 of your folders. Now, Chile has been noticeably silent about the contents of this agreement, and it did not bother to annex a copy of the draft agreement in its written pleadings, nor in its folder of so-called key documents distributed last week. Nonetheless, despite the reticence of our colleagues on the other side of the bar, several points stand out from the 2009 draft agreement that provide important context both for Bolivia's submission that it is entitled to an equitable and reasonable utilization of the waters, and for Bolivia's second and third counterclaims. First, in the initial agreement, Chile recognized that Bolivia was entitled to at least 50% of the flow, notwithstanding that Bolivia was not then making use of the waters. Bolivia's share of the water, that 50% share, could be increased as a result of the scientific studies to be undertaken, but it would not be decreased. That was in Articles 2 and 6 of the agreement. Now, that stands in stark contrast to Chile's threat in its application to request provisional measures if Bolivia engaged in any conduct that would have an adverse effect on Chile's current use of all of the waters of the Salala. Second, under the initial agreement, Bolivia could abstract its share of the waters for internal use or sales to third parties, including to Chilean entities who had a right of first refusal. That was in Article 3. Third, Chile agreed that its public or private entities would pay compensation for any of the waters freely available to Bolivia and abstracted in Bolivia's territory that were delivered to Chile, with a formula proposed for assessing how that compensation would be determined. You'll find that in Articles 3, 13, and 14. And fourth, the parties agreed that no works would be undertaken either individually or jointly that could affect the quality or quantity of the existing cross-border flow. And for practical purposes, that meant that Bolivia could not unilaterally dismantle the canal works, which inevitably would have had some effect on the quantity or quality of the waters. Now, in contrast, Chile now states that Bolivia is fully entitled to dismantle the channels, provided that it does so in accordance with international law. But that was not its position in 2009, and it wasn't its position when it issued its threat for provisional measures in its application, and there's no certainty that it will remain Chile's position in the future. In November 2009, a revised draft of the initial agreement was prepared, which you'll find under tab 5.3 of your folders. It contained most of the substantive provisions of the July draft, with some minor amendments advanced by Bolivia that were by and large uncontroversial, together with the statement at the beginning, in a new Article 1, of each party's general position on the status of the waters. So that was the situation at the end of 2009. In October 2010, at a meeting of the Working Group on the Salala issue, Bolivia proposed the inclusion of an article in the initial agreement that would address past Chilean uses of the waters and the issue of compensation for such uses. And Chile rejected this suggestion. And Chile also rejected Bolivia's position that Bolivia should be entitled to use the freely available waters in its territory or to reconstitute the natural conditions of the Salala Springs, which inevitably would have involved dismantling the channel works. And as a result of Chile's refusal to continue discussions on the initial agreement, further work to finalize that agreement came to a halt. Now, notwithstanding this, it is important to note that the parties at that time in 2010 had no disagreement over the substantive provisions that were included in the 2009 draft. Any disagreement related to Chile's past use of the waters and whether there was any compensation due to that, whether from Chile or from the private FCAB company. While the initial agreement was never signed, and thus did not come into force, the parties' positions as reflected in the drafts of that agreement are instructive because they provide an indication of what they considered equitable and reasonable at the time. And in fact, it's the only indication we have. As the court noted back in its judgment in the Tunisia-Libya case in connection, in that case, with a continental shelf boundary between the two countries, even though the parties' conduct in that case did not rise to the level of even a tacit agreement, the court stated that it is evident that the court must take into account whatever indicia are available of the line or lines of which the parties themselves considered to be equitable or acted upon as such." End of quote. And Bolivia would suggest that in the present case, it's equally appropriate for the court to take into account the indications of what the parties considered to be equitable reflected in the draft 2009 initial agreement. Now, following the breakdown of discussions on the initial agreement, Bolivia explored ways in which it might make use of the waters of the Salala in its territory and other activities. I've discussed this in my earlier presentation, the idea of constructing the weir, the bottling plant that never went forward, the fish farm, military outpost, and 10 small houses, none of which gave rise to any risk of significant, or in fact any, transboundary harm, and the fact that Chile never alleged the contrary. Now, that's all, Madam President, I wish to say about the background facts at this stage. I now turn to the specifics of Bolivia's second and third counterclaim. As I noted at the outset of my presentation, in its second counterclaim, Bolivia referred to its sovereignty over the artificial flow of the Salala waters, engineered, enhanced, or produced in its territory, and that Chile has no right to that artificial flow. Chile's taken issue with the reference to Bolivia's sovereignty over that flow. And Professor Boyle, speaking on behalf of Professor McCaffrey, to whom we send our very best wishes, argued that international law does not recognize such a concept and that it runs counter to the principle of equitable, reasonable utilization of shared water courses and the community of interests of riparian states. And I shall explain why Chile's contentions in this respect are misguided and why Bolivia's counterclaim B is both logically sound and legally justified. The parties agree that the man-made waterworks were constructed by a private enterprise in Bolivia's territory, and they also agree that as a consequence, Bolivia has sovereignty over the waterworks, which includes, amongst others, the right to dismantle those works to restore the wetlands if it so chooses. Chile cites no principle of customary international law that would deny Bolivia that right. To the contrary, Chile has made it abundantly clear that Bolivia possesses this right, although it only did so after these proceedings had been instituted. To recall Chile's words in its reply, and I quote, "Chile does not dispute Bolivia's counterclaim A, the counterclaim that Professor Forteau addressed, that Bolivia has sovereignty over the artificial channels and drainage mechanisms in the Salala that are located in its territory, and therefore has the right to decide whether and how to maintain them." But the corollary of that admission is that Chile has no legal right to insist that the enhanced surface flow or the artificial flow produced by the channel works must be maintained. It is Bolivia's sovereign right to take that decision. And it is in this sense that the reference in the first part of Bolivia's counterclaim B to its sovereignty over the artificial flow of the Salala waters, engineered, enhanced, and originating in its territory, it's in this sense that that should be understood. Bolivia can decide if the waterworks that produce the artificial flow remain or not. That is Bolivia's sovereign decision. And for the same reasons, the second part of Bolivia's counterclaim B, that Chile has no right to that artificial flow, necessarily follows. It has no acquired right to the current flow, the enhanced flow produced by the waterworks in the future if Bolivia decides to dismantle the channels, as is its right. So contrary to Professor Boyle's contention, there is, in this respect, a difference between the natural surface flow and the enhanced or artificial flow. And we know that Chile has obviously benefited from that flow for many years, but it has no acquired right to continue to receive the enhanced flow produced by the channels and the drainage mechanism in the future, as I said, if Bolivia decides to exercise its sovereign right to dismantle the infrastructure. In other words, the equitable and reasonable utilization principle does not oblige Bolivia to maintain the waterworks, and therefore Bolivia maintains that its counterclaim B is fully justified. Now, to come back to a point that Professor Pelé made yesterday regarding Bolivia's entitlement under international law to an equitable and reasonable share of the waters of the Salala for future uses, there are several factors that Bolivia submits to be taken into account that arise as a consequence of Bolivia's counterclaim: A, the right to dismantle the works, and B, Bolivia's sovereign right to decide whether the enhanced flow remains or not. And these factors include the following. First, a central reason for dismantling the canals would be to restore the bofedales, the wetlands, and the environment to its natural condition. And I think there can be no dispute that the protection and preservation of the environment is a key principle of international law. As you've heard, the bofedales are a part of a Ramsar site, the Los Solipes site in Bolivia, that have been designated for protection in accordance with the Ramsar Convention, to which both Bolivia and Chile are parties. And as noted by the Conference of the Contracting Parties to the Ramsar Convention, and I quote, "A key requirement for wetland conservation and wise use is to ensure that adequate water of the right quality is allocated to the wetlands at the right time." That is not what the channels have done. Now, Chile criticizes the Ramsar report that concluded, based on a site visit to the wetlands, concluded that the Bolivian wetlands had been degraded due to the channel works. And as Professor Eckstein recalled, although Chile criticizes this Ramsar report, Professor Eckstein recalled yesterday that the court itself has observed in its judgment in the certain activities and construction of a road case that the presence of Ramsar-protected sites heightens the risk of significant damage because it denotes the receiving environment, that the receiving environment is particularly sensitive. That's what we're dealing with here, a particularly sensitive wetland. Moreover, the criticism of the Ramsar report by Chile defies common sense. You saw those canals yesterday on the diagrams and on the video. Clearly, they drained the waters from the wetlands. A recognized method for draining and drying out stagnant or standing water is to dig a series of canals to drain the area. You really need to look no further than the canals in the Netherlands to appreciate the point, albeit obviously on a larger scale. For present purposes, the key point is that Bolivia should not be penalized with respect to its equitable and reasonable share of the waters of the Salala by the dismantling of the canal works for environmental reasons in order to restore the bofedales. The second factor worth taking into account is that the parties and their experts agree that a substantial portion of the waters associated with the Salala system in Bolivian territory comprises groundwater, and that this groundwater flows downhill into Chile from Bolivia. Last Friday, Chile's advocates repeatedly emphasized this point. In Professor McCaffrey's words, the groundwater of the Salala, and I quote, would all eventually flow to Chile anyway, and that the total quantity of water making its way to Chile remains the same, however it gets there. Chile also stressed that groundwater forms part of the watercourse along with the surface flow under international law. To the extent that dismantling the canals causes a significant decrease in the surface flow, as Bolivia's experts have shown would be the case, the groundwater will increase. No dispute on that. However, in that event, Chile will be able to recover the corresponding groundwater in its own territory as a major part of its equitable and reasonable share. Indeed, Chile's agent noted on Friday that groundwater sources, which are part of the Salala watercourse system, already contribute some 124 liters per second of additional water, groundwater, that flows into the Salala just downstream of the boundary. So Chile's getting the 160 or 170 liters per second of surface flow, but they're also, just down from the boundary, benefiting already with an additional 124 liters per second of groundwater flow. Take that into consideration in considering what is equitable and reasonable in the future. Third, in assessing Bolivia's equitable and reasonable entitlement for future uses, account should also be taken of the fact that Chile has obviously benefited for many years and continues to benefit today by having had use of all the waters, all the cross-border flow, and the groundwater flow. And Chile has used the waters not simply for human consumption, but for industrial purposes as well, without informing Bolivia of these uses, at least not until these proceedings. While Bolivia does not take issue with Chile's use of this flow up to the present, the application of equitable principles that dictates that this factor, along with the others I've mentioned, should be taken into account in assessing Bolivia's entitlement. Now, in the remaining few minutes, I'd like to turn to Bolivia's third counterclaim. You'll recall it's on the screen. I won't read it again. You've seen it. It concludes, it involves the need for an agreement. If the current situation or the current status is to be maintained. So this counterclaim addresses the situation where Bolivia decides to dismantle the canal works, as is its right, and Chile indicates that it would prefer the waterway works to remain in place and to receive the delivery of the enhanced surface flows caused by those works, i.e. the current flow, which would be over and above what it would otherwise be entitled to under the equitable and reasonable standard as applied to the natural surface and groundwater flow without the waterworks. Now, obviously, Bolivia is well aware that in these proceedings, Chile has stated that it has no objection to Bolivia dismantling the channel works. And if Bolivia dismantles the channel works, Bolivia's third counterclaim, which looks to the future with the canal works still in place, would be without object, as Professor Forteau already noted. But as I have explained, this agreement or encouragement for Bolivia to dismantle the canals was not Chile's position in the past when the parties negotiated the 2009 initial agreement, and it was not Chile's position in its application, where Chile reserved the right to request provisional measures should Bolivia engage in any conduct that may have an adverse effect on Chile's then current use, i.e. with the canals, of the waters of the Salala. In other words, it's entirely possible that Chile's position may change in the future, particularly given the risk, as demonstrated by DHI, that dismantling the canal works could significantly reduce the surface flow that crosses the border. Now, Chile argues that this surface flow, groundwater flow distinction makes no difference because all the water flows into Chile. But the fact of the matter is, in the past, it certainly did make a difference. FCBAB and the Chilean company Codelco built 3 intakes to siphon off the surface flow. They were only interested in the surface flow. And there's no evidence that they used groundwater. Bearing in mind that Chile has no acquired right to continue to receive the enhanced surface flow produced by the channels, in the event Bolivia decides to dismantle those channels and Chile reverts to its former position that it wants the current claim to be maintained, Bolivia submits that it's entitled to be compensated. This would include the cost of maintaining the channels and the value of the enhanced surface flow resulting from the canal works that would thereby continue to flow across the border into Chile over and above what Chile would be entitled to based on the natural flow of the waters. And that value or compensation could be used by Bolivia also to help restore the wetlands. And the notion of compensation from Chile for the delivery of waters is not novel. As I noted earlier, in the 2009 draft initial agreement, in that agreement, Chile agreed to compensate Bolivia for any waters abstracted by Bolivia in its territory forming part of Bolivia's agreed share that were delivered to Chile. In fact, Chile even wanted a right of first refusal to purchase those waters. And there was a formula for valuing that. So in the present case, the conditions, modalities, and compensation due to Bolivia for keeping the channels in operation and maintaining the current flow would also need to be negotiated between the parties. And this is what's reflected in Bolivia's counterclaim C, which states that these elements would be subject to an agreement. As Professor Pillay observed yesterday, international law in general and the 1997 Watercourse Convention in particular encouraged the conclusion of such agreements between riparian states. As he recalled, the ILC in its 1994 report emphasized that the optimal utilization, protection, and development of international watercourses are best achieved by means of agreement tailored to the specific characteristics of the watercourse in question and the needs of the concerned states. And Bolivia's counterclaim C is advanced in this spirit and is designed to meet the particular and really quite special circumstances characterizing the waters of the Salala in their upper reaches in Bolivia and the interest and needs of both parties. And there's absolutely nothing in Bolivia's third counterclaim that runs counter to international law generally or the community of interests principle mentioned by Professor Boyle. That, Madam President and distinguished judgment, is the essence of Bolivia's third counterclaim. Second and third counterclaims I've discussed that Bolivia considers are fully justified given the particular circumstances of this case. It brings me to the end of my presentation on counterclaims B and C, and also it brings us to the end of Bolivia's first round presentation. I thank the Court very much for its attention.
I thank Mr. Bundy, whose statement brings to the end this afternoon's sitting. Oral argument in the case will resume on Wednesday, 6 April at 4 p.m., when Chile will present its observations on the counterclaims of Bolivia. The sitting is adjourned.